All right, we are live. Hi, everyone, and welcome to today's fast-paced session, Certified Payroll Challenges, Real-World Mistakes and Recovery Tactics. I'm Shauna Coronado, your host, and I'm excited to guide you through this focused 30-minute webinar. Now, we have housekeeping. Before we dive in, let me quickly show you how to get the most from our time together. And while we're chatting today, keep an eye out for our exclusive resource download. We'll be dropping a button down below so you can grab our helpful guides available only to live attendees. So submit questions anytime using the chat and the Q&A tab, and we'll address them when we wrap things up. Now, we have a fantastic chat moderator, Michaela, who will be happy to help in any way possible. So she'll be over and chat with you, and we'll answer questions that you have about our experience today. But please use the chat to engage with us and other attendees. And it's especially important that you keep an eye out for interactive polls throughout the session. And your participation helps us tailor this discussion to what matters most to you. And speaking of the chat area, we're already going over there. But while I go through what we'll cover today, drop your state in the chat so we can see where everyone's joining us from. And also, at the end of the session, we'll have Q&A. So we will answer all of your questions there. So as the session goes through, please ask us questions in chat and we'll help you out. We have two outstanding experts with us this session, Danny Goldberg, the Vice President of Sales at eBacon, and Michael McCoy, founder of PWCA and a national authority on certified payroll compliance. This session will explore the most common certified payroll form submission mistakes, what to do when rules change mid-project, how to respond when an audit uncovers problems, the impact of fringe benefit calculation errors, and how to fix them. All right, so we have people, a lot of people from California are showing up over here. Oregon, California, but Michigan, all over the country, we have people. So welcome, everyone. Let's get right into it. So Michael, let's start it off with form submission, errors, and recovery.
Sounds good. Welcome, everyone. Greetings to everyone. Hope all is well. We want to talk about form submissions. And depending on your state, we want to begin by asking the question, does your state have its own prevailing wage laws and procedures separate from the Department of Labor's Federal Davis-Bacon Act? Some of your states are considered what are called Little Davis-Bacon states. California, of course, is the most onerous of all states when it comes to prevailing wage documentation. And so it's critical that a certified payroll specialist or those of you in HR understand the proper form submissions on documenting your public works projects, beginning, of course, with the bid document. And of course, you have to work very closely with your construction team so that you can properly onboard a public works project. The bid document contains all of or much of the compliance requirements you will need in order to structure the forms that are needed for routine compliance. If the project is state funded, then you have state compliance. For example, in California, you have DIR. In the state of Washington, you have the Department of Industry. Each state has their own forms for which you have to submit and a timetable as to when those forms are required to be submitted. And so you want to make sure that forms are submitted timely. You do not want to be late because there are fines and penalties for being late with those filings. And so forms, your initial forms and your onboarding forms are very important from state to state.
Do you have more information for us on apprentice violations, Michael?
Yes. Part of the form submission deals with apprentices. And for those of you who are subjected to apprentices by craft, be mindful of this. Since the inception of our company at PWCA, we have a legal department and we average about 150 open cases at any given time. Every single case from our inception all have apprentice violations. For that reason, you want to be very, very careful on meeting all of the apprenticeship requirements for your state. Now, Federal Davis-Bacon under the Department of Labor does not mandate apprentices, but it allows for apprentices. Your general contractor or the awarding body in their contract will let you know if the project requires apprentices. But you want to avoid apprentice violations and make sure that you comply with the strict mandates for apprentices, especially in California, New York, and other states where, in the state of Washington, where apprentices are required.
Hey, Michael, can I just ask one thing, Shauna? Michael, last week we had two prospects we were talking to, and this is California specifically, but they were just calling in and asking for apprentices and not actually sending in the DAS 142. Can you talk about the issues that can happen with just not doing what the state says?
Yes. Well, calling in does not work. Everything must be documented. So let's talk about California specifically. When you recognize as a certified payroll administrator for your company, when you recognize you have apprenticeable crafts, you must timely submit your DAS 140, which is a notification to apprenticeship committees, letting them know that you have received a public works project. It is a notification that must be done within 10 calendar days, not business days, within 10 calendar days of receiving the award. Then you have to timely submit your DAS 142 at least 72 hours or 3 business days. That's business days, not calendar days, before you need the apprentice. You cannot call in and be covered with calling into the apprenticeship committee or calling the union. You have to use the requisite forms if you want to be in what we call in law safe harbor. All of you want to strive for safe harbor to protect your companies.
Very, very good. Let's move on to a poll. Let's ask everyone, what certified payroll issue consistently demands the most time and attention from your team? So go ahead and click that answer on the screen, all you attendees, and let's see what kind of answers we come up with. There are a lot of things here that are concerns: form errors, apprentice violations, mid-project regulation changes, and audit findings, fringe benefit calculations. So far, we have 100% on that. Oh, great, great. Fringe benefit is a huge concern, I can see already. And about 45% of people are saying fringe benefit. That's really, really important. Okay, let's introduce a new slide. Let's talk about regulation change response. It's a concern. Let's check in with what happens when rules change mid-project. Danny, give me an idea of what to do when rules change like that.
Yeah, help. You just need to make sure, whether it's your attorney, whether it's your compliance officer, whether it's a friend or somebody that really understands the regulatory stuff and the changes that can happen. These states kind of just go crazy sometimes. And just because you didn't know it, because ignorance of the law is no excuse. You have to know what's going on with every project in every county and in every city that you're doing business in. And just because you did it that way in the past, it doesn't mean it's going to be that way going in the future. Things change. Fringes change. And I saw that on the survey that we just took, fringes are a problem. Calculating it correctly, when does it happen, all that kind of stuff. It's extremely important to have, like I said, that confidant, that compliance officer, somebody to really help you understand this. And just because you hired Mary, who's got 30 years of experience in prevailing wage, It doesn't mean that's always the greatest thing to do, guys.
Mhm.
It's a challenge out there.
It is. What about emergency compliance recovery steps? Do you have any advice, Danny? When facing sudden rule changes.
Call your attorney.
Really?
Well,
Okay.
just ChatGPT can help a little bit, actually a lot, but you just got to talk to. I would talk to counsel. You guys, I keep using you guys. It's my Chicago personality. I'm sorry, but you just have to make sure you're talking to the right person to do this. I would call counsel. It's worth it. I would call a consultant. It's worth it. It's not worth what can happen to you if you're wrong. The fines and the penalties are insane.
May I chime in for a quick second?
Yes, please, Michael.
One thing regarding regulatory changes. Danny is absolutely right. However, I will warn against this. Most business attorneys do not know prevailing wage law. Ladies and gentlemen, you need a prevailing wage certified payroll consultant that lives, eats, and breathes prevailing wage on a daily basis. Otherwise, you're going to be paying attorneys for on-the-job training on trying to figure out the regulatory changes and the effect it will have on you. You need a compliance consultant that will know what these changes are and what immediate impact they will have on your public works projects. Period. End of story there.
Yeah, very good for our category here, communication strategies with agencies. Having an agency that's qualified is what you're saying is really important.
Absolutely.
Okay. Michael, when a regulation...
Yeah, Michael, thanks for that.
You go ahead, Danny.
Oh, sorry. One last thing. We talked to several prospects in the last month, and I think the lowest fine or penalty that they've seen if we can help them with was the low end was $100,000. These are companies under 20 employees.
Yes.
It's insane. So, Michael, you want to talk about that a little bit?
One thing I want,
these fines?
Yes, for all of you who are in charge, if you are the person, listen carefully to what I'm about to say. If you're within the sound of my voice and you are the person in your company who's responsible for accurate certified payroll submissions to the state or to the federal government, your job is to protect your company, because here's what happens. If something is in error and it's in your system, what happens, fines and penalties compound by the day. So let's say you underpay a worker. Simple mistake. You underpay a worker and that worker is underpaid. In California, the penalty could be as much as $200 a day for every day that worker is underpaid. Now, in California, it takes the DIR, the Department of Industrial Relations, on average about 1 year to discover a problem or a violation. Now, get this, that one violation compounds for every day that worker is underpaid. That's $200 a day times 365 days. That's how you end up with six-figure fines and penalties on a very simple violation. That's why onboarding from the very beginning is absolutely essential.
Makes sense. Michael, along those lines, if there are unexpected costs, these costs, that fines and all of this that pop up, how do the accountants and the payroll managers out there really manage that unexpected surprise? What is the step or the process that they should go through?
Well, the problem is once you are in the lion's den, meaning the state or the federal government has discovered a violation, now it's hard to back out of it because you're in the lion's den, so to speak. Again, the best preventative measure is starting out when you're not in trouble. You want to begin with sound onboarding procedures with all of your requisite documentation. Let me back up a little bit further.
Mhm.
What is also essential, if you want to stay in safe harbor, is you need effective communication with your construction team. When I talk about your construction team, I'm talking about your project managers, your estimators, your salesmen, those guys and gals who are out there bringing in the deals, getting all excited about the deals, but they could not care less about the paperwork. You cannot be late, ladies and gentlemen, on submitting your documentation on public works projects. That's where it all begins. And so what happens is once you are under investigation by the state or feds, now it becomes a problem where you have to hire a professional to help you mitigate against the fines and penalties against the state and federal, because they're just so unforgiving. So it's a very unfortunate situation. So the best defense is a good offense, meaning
Very good.
starting from the very beginning, making sure you're not going to have problems from the very beginning.
I got you. And along with this, since we're still on this topic and it's an important one, Michael, when a regulation change blindsides a project, right? When something changes, what's
Yes.
the first thing a payroll manager should do to avoid project delays?
Immediately notify your general contractor of the regulatory change and notify them in writing the effect it will have on your portion of the project. In other words, you want to receive guidance and direction from the up the chain contractor or the awarding body.
Very good. Let's go to the next slide, which is audit response and recovery. What happens when auditors find problems? Michael, this is a question that is really a challenge. What do you think?
It is. And when auditors find problems, again, I want all of you to understand, and me as I fight these cases in court all the time, these auditors are like termites. Once they taste wood, they just keep chewing. And that's the purpose of their existence. And again, my best advice there is that when in fact you are confronted by a government official regarding an investigation, make sure your files are ready and accurate and ready for submission, because you want to make sure you timely submit the documents, for example, your payroll records, upon request, because if you fail to submit within a certain amount of time, the fines and penalties begin just for waiting for you to get your act together. The penalties could be just egregious just because you're not organized. And I can tell all of you within the sound of my voice, I can tell all of you, 95% of you have projects where files are either disorganized, certified payrolls are not actually certified. You don't have them right there at your disposal. Files are scattered. I tell you, that's the biggest problem when dealing with an investigator. So again, you want to be prepared by being on offense, anticipating that there might be a problem. And I think that's a key point. When you're dealing with a public works project, you have to anticipate that there, or I say should, not have, but you should be in a position to say, you know what, there could be a problem. Let me be prepared and get prepared right now so that when something should happen, I'm ready.
Well, since we're on this topic, Crystal has asked a question. I know I said all the Q&A will be at the end, but this is so applicable right now. She asked, what type of docs are required to be sent to an auditor?
Okay, great question. It depends on who the auditor is. For example, if the auditor is from the state, they're going to ask for the entire project file for that particular project. They're going to want all of the certified payroll records. But then you could be audited by a union.
Oh.
Yeah, a union auditor. And sometimes a union auditor will ask for payroll records on that project and other unrelated projects. And so, again, this is why having a compliance attorney or a compliance specialist, a consulting firm available to you, so that the moment you receive a notification of an audit, you can call and say, hey, what should I do with this audit? It is from the DIR, state of California. What must I send them? And what should I not send them? Because here's some of the problems. Sometimes too much information can come back and hurt you more than the actual information the auditor is asking for.
Oh, that makes sense.
Well, one other quick story for those listening is we had a prospect not too long ago that was audited and sent like a year's worth of manual time cards. I mean, handwritten sheets, and the auditor couldn't read them. And it sat on the auditor's desk for about 2 or 3 months, and there was no communication. Fines and penalties. I'm not going. I can't read this chicken scratch. So the auditor wanted them to go back and recreate every single paper punch, if you will, to be read. A year's worth.
Oh, that makes sense too.
Yeah.
It's so frustrating. While we're still on this particular slide, one issue that people have is negotiation. Michael, what's your advice for smart negotiation approaches that have successfully reduced penalties?
Again, another tough one, but the best negotiation is, again, having good documentation to show the state or the union auditor that you were operating in good faith. That's the number one defense when you're under an audit, is you want to be able to produce sound documentation, starting with number one, your certified payroll records. Okay, making sure that your certified payroll records, like Danny just articulated, are legible and ready for immediate inspection. You want to make sure your certified payroll distinguishes between journeymen and apprentices on the job site. You want to make the auditor's job as easy and as painless as possible. Okay. So you want to begin right there by making sure that your certified payroll records and your project files are complete and ready for review. Okay.
Okay. We do have one last line on this slide, and I really think it's so very important for our listeners. Post-audit compliance systems that prevent repeat findings.
Okay. Well, there, post-audit, in other words, let's just say you've gone through now an audit. You've been found guilty of violations. You've been able to now mitigate it down to something more manageable. Like Danny said, it's easy to have a penalty of 100 fines and penalties and back wages of 100,000. But let's use that as an example. You were able to mitigate it down to say 30,000. You reach a settlement with the state and you pay it off. Here's what all of you need to know about an audit and or a violation. These violations and these investigations become part of your public works record. So think of it like a criminal record. If you get caught drinking and driving and you get a DUI, it goes on your record. Well, public works violations go on your company's record. And so the auditors and the state, you're going to be on their watch list now for example, apprentice violations. If you've violated apprenticeship rules in the past, the state is going to be hypersensitive now to you violating apprenticeship requirements in the future. That means you need to really fortify your procedures and get some training, people. Oh my gosh, I cannot scream from the mountaintop any higher than that. Many people think they know it all when it comes to certified payroll. They've said, well, I've been doing it for 20 years and I've never had a problem. I've been doing it for 15 years, never had it just means you haven't been caught. Get some good training where you go to a workshop with someone who will call you out and expose you for what you think you know, not one of these seminars or workshops where they just want to hear themselves speak. You want to go to a seminar where the instructor calls you out based on the procedures that you're operating on in order to find gaps in your workflow.
I understand. So let's go to a poll and ask, how many times have you been audited in the past year? I would love to hear from the audience how many times they've been audited in the last year. Is it one time, 3 or more? None. Okay, that's good. I like to see 83% is none. Up, it's moving. But there are some that have said 3 or more times. That is a huge concern. And I know we are wanting to prevent the audits as much as possible. So Danny, let's go to the next slide here. Fringe benefit calculation errors. Let's examine when benefit calculations are really questioned.
Hi, I can. We're coming to our 30-minute witching hour here.
Keep going.
Yeah, God, fringes are one of those delicate things. For instance, you've got a job group 1 through job group 10, and we've got some people that just say, well, and it's $30 an hour and fringe up to $37.50 an hour. And some people just say, I'll just charge $37.50 an hour because I figured that's the highest amount, so we're covered and we're not in trouble. That's not the right thing to do. It can cost your company an obscene amount of money. You're in a low margin business anyways. That's not a healthy thing to do. Again, like Michael had said earlier on, you just got to talk to somebody, have a confidant to understand how to go through all this stuff. The financial implications are huge. Restituting payroll are huge. Mike, like I mentioned, we had a 10 or 15 man company that over $100,000 penalty because there were 2 people that they didn't pay correctly on the job. A year later, $200 a day, $120,000 for 2 people. Unfortunately, that company is probably not going to make it. They just don't know what to do. And if they were looking for us to help them, that's kind of not what we do going backward. You just got to get this stuff right. Documentation required for proving good faith compliance efforts. So when I mentioned about operator 1 or operator 10, why did you pick an operator 4? Why did you pick an operator 5? Because this is what we do. We're a backhoe organization that it says backhoe and operator 4. It doesn't say it in 3 or. Those are the kind of things that you want to make sure of proving that's what you did. You can argue later with the auditor, but again, the proof on why you did it that way makes all the sense in the world and will help you should you get audited.
Yes, that makes sense. And Michael, what are some strategic approaches to minimize penalties while ensuring the proper compensation for people? Oh, Michael, we can't hear you. We lost your sound.
I'm sorry.
Now we can hear you.
Okay, my mistake. Yes.
No worries. Go again.
There's some construction noise going on. I just muted. Yeah. Again, I cannot stress enough about onboarding from the very beginning. Some compliance companies, for example, I think this is a really good program that many of your listeners should take advantage of. Check with some of your compliance specialists in your area and ask them if they have what they call a Kickstarter program. And what a Kickstarter program is it's a low cost way of having a compliance specialist help you onboard your project, including your fringe benefit calculations, when you first take on a public works project. That way you will not have any problems down the road. That's the issue with public works is if you start poorly, then it's going to be very difficult to mitigate and fix it when it's discovered 6 months later that you've underpaid a worker or your fringes are improperly calculated. And so the onboarding process is important, making sure that you have it set up from the very beginning, or you could pay the workers the fringes in cash. Mm-hmm. And that's another simple way of avoiding fringe benefit calculations is follow the mandate as found on the DIR's website on the wage determination for California, or for example, in the state of Washington, just follow the fringes as stated on the mandate. And if you pay equal to or greater than the prevailing wage rate and you pay the workers in cash, the fringes, chances are you're going to be in good shape all the way through.
Oh, go ahead.
No, I like to add one more point to that because about 50% of the prospects that we talk to do pay their fringes in cash. But you need to be very careful on what you're actually doing. If the fringes are $30 an hour and you're also paying your employees PTO and you're paying your employees health insurance, you're double paying because part of that $30 an hour fringe is including those fringe benefits.
Good point.
We're learning this a lot. The biggest thing is that like the 69, 79, or 89 cents training fund, especially in California.
Yes.
We've got prospects that are paying the $30 an hour, which is inclusive of that 69 cents, and then sending the 69 cents an hour to the state. You're double paying $1,500 per employee.
And that hurts your company.
That's insane, guys.
It does. It does. And now we are at 30 minutes, and this is supposed to be a 30-minute webinar, but we are going to move on to Q&A and answer questions. So if you have to go now, I understand, but I hope that you'll stay. And at the end of the Q&A, we'll have a link for you so that you can get all of the free benefits, all the prizes that we're going to give you at the end, and that'll be really helpful. So I am jumping over to the questions on in our chat. And one of those questions is from Crystal. And since we're on the topic of Fringe, this is on what qualifies as a Fringe reduction is what she's asking. Michael, do you want to take that?
When she says a fringe reduction, I don't understand what's meant by it. I don't know. Is she referring to what is referred to as a credit?
You know,
as a fringe credit?
Crystal has not said that, but at the end she asks again, can you touch on fringe reductions? So Crystal, if you can ask a more detail, yes, she says, yes, a credit is exactly what it is.
Credit.
Mm-hmm.
Okay. Yes. There are certain employer payments that are made to the benefit of the worker. Each state, I can't give you a blanket answer because each state has a different or could have a different rule. However, if your state allows contractors to take a credit for employer payments, the first thing you need to find out is what credits are or what payments are actually eligible to be taken as a credit. For example, in California, health and welfare is considered a fringe benefit or an employer payment that could be used as a credit against the fringe benefit credit. And so holiday, for example, holiday benefits is considered an eligible expense that is eligible for the credit. And so California has a list on the DIR's website. In California, there is a list of eligible expenses that are within the realm of receiving the credit. And so again, depending on what you're paying out for the benefit of the workers, you want to make sure that those credits are eligible and you could take them accordingly.
Excellent. Vicki, it's a statement question. I'm going to read it. It's a little bit longer. Please be patient. Vicki says, I attended the DIR conference in Ontario, California yesterday, Canada, yesterday, and the investigators all mentioned that any communication requesting for an apprentice to be dispatched should be documented. Most schools or entities that dispatch apprentices have internal systems for requesting an apprentice, and if they do not dispatch one in a timely manner, it must be documented to help protect your company in the case of you getting audited. Emails suffice as documentation. Is there anything else you can add to that, Michael?
I think that's a very good question. In California, let me just speak for California. The statute in California mandates that you are required to submit your DAS 140 and your DAS 142 one time per project.
Okay.
But you have to do it for each craft, one time per project for every craft. If an apprentice is not dispatched, it is not on you. But beware that if there's an audit down the way, the state is going to ask you to produce your DAS 140 and 142, and you must meet what is, and this is required for every state in this regard, if they require apprentices, you must meet what is called the two-pronged proof test, meaning you must prove that the documents were sent. That's the first prong. And the second prong, you must prove that the documents were received by the other party, meaning the apprenticeship councils or the apprenticeship authority or the union.
Okay, that's good
Yes.
to know.
Yes.
Crystal is asking another question, which is the rule considered by state, which is the rule, the fines and penalties for underpaying a worker?
I'm sorry, I don't understand that question. Can you ask it again?
Yeah. When we were talking about underpaying workers,
Yes.
and she was wondering, is the rule that applies to that by state for every state, or is it just because she was told that was not the way it worked in Illinois?
Yes, I'm not sure of the laws in Illinois. I don't know, as I sit here today, without checking our compendium for the state of Illinois, I do not know what the per diem penalty for underpaying workers is. I do not know that as I sit here today, but I do know that every state has a penalty for paying less than the prevailing wage rate. I need all of you also to be mindful of this when it comes to paying workers and underpaying workers. You wouldn't underpay a worker the state's minimum wage rate, would you? No, because automatically you would be in violation of state law. That's across the entire United States. You would not underpay the minimum wage rate. Well, prevailing wages on a public works project is nothing more than the minimum wage rate for a construction worker on a public works project. So there will be penalties should you underpay that worker. And it's discovered by an auditor later on.
Of course. There's one last question here, and it is, I'm not sure how it applies, so you'll have to help me with this, Michael. King asked, is there a citation for the training? And I don't know what that referred to. I apologize. King, can you give us more detail if you're still here?
Yeah, well, there's definitely in California, for example, you have the CAC, the California Apprenticeship Council, and the DAS, the Division of Apprenticeship Standards. Those two organizations in California are the governing bodies and the regulatory bodies for training fund contributions that are required to be paid for every hour a prevailing wage worker works. And those training funds are never to be paid to the worker, as Danny alluded to earlier. Those training funds are to be paid to the state. And by the way, I can't say never, because there is a rare instance where training does go to the worker. And that would be for if, for example, let's say you have a craft that is non-apprenticeable, but the wage determination has a training obligation. Then the training fund, like say if it's 22 cents or 35 cents or whatever it is, in that case, if it's a non-apprenticeable craft and the wage determination has a training fund obligation, then of course that money can go to the worker. But that's rare, very rare.
That is, King confirmed that it's the training credit that you're discussing. So yes. And then we have one last question, and this is from Stephanie. She says, is a fax sent transmittal sufficient for a DAS sent received confirmation?
Absolutely.
Yay. Yay, that's excellent news. Well, that was a simple answer. You only used one word to answer that one.
That's
not the way he said the word.
Wow. Okay. That was great. Okay. Thanks for everyone for joining us for this quick yet packed session. And Michaela, if you can put up the little link for us down below so that, there we go, today's exclusive resources. Click on that baby, because it's going to give you all kinds of freebies and resources and guides that will help you. For all of you live attendees, thank you for joining us. And if you'd like to explore tools that help prevent certified payroll headaches, visit eBacon.com and check out our webinar resource hub. And we'll see you next time. And remember that mistakes can be fixed, but only if you know what to look for. You have a great day. Thank you.
Bye.
Bye-bye.